Thank you, Gloria. All right, welcome everyone. Good afternoon. We are so excited to have so many people joining us for today's really important topic, understanding how protective orders can help prevent gun violence. And thank you so much. We have Jeff, Toney, and Alyssa Gutierrez with us today. Before I introduce both of them, we're going to present a couple of slides just on some housekeeping. So we did put a link in the chat for a pre-survey, and then we'll be putting one for a post-survey at the end of today's meeting. So please go ahead and fill out that survey. Since we're also in a webinar format, as Gloria mentioned, please put all of your questions or comments in the Q&A, and we'll get to those at the end of the meeting. And then you will be given a PowerPoint copy at the end of today's meeting. And so welcome to our two speakers. We have today Jeff Toney, who brings over 15 years of experience in emergency management services, including working for the California Governor's Office of Emergency Services, and most recently as the director of San Diego County's Office of Emergency Services for 5 years. He's also worked as an instructor for the California Specialized Training Institute, teaching emergency planning, mitigation, recovery, and emergency operations center management. Additionally, he has worked as a legislative and policy analyst across multiple government agencies and has a deep understanding of municipal and state operations and politics, complementing his vast experience in emergency management, planning, and training. So welcome, Jeff. And we also have Alyssa. Alyssa Gutierrez is a senior account executive of emergency services at Bodewell Group, where she brings more than 9 years of experience in public safety, law enforcement, and crisis communications to support training, preparedness, and emergency management initiatives. Drawing from her tenure as a former public information officer with the California Highway Patrol, Alyssa has extensive experience developing and delivering safety training for both law enforcement personnel and civilian audiences. She has designed and facilitated public safety training focused on emergency response coordination, situational awareness, and active shooter preparedness, helping agencies and community organizations strengthen their readiness for high-risk incidents. So on behalf of the Domestic Violence Council, I am your president, Annalise McKee-Chow. I'm with SBCS and so happy to welcome our presenters. So take it away.
Thanks so much, Alicia, and thank you all for joining us this afternoon. Alyssa and myself, we're very, very proud to be a part of this campaign. For me, I started my career at Cal OES at the Governor's Office of Emergency Services, so working with them again in a different capacity. I'm very happy to do that. And as a former county employee, I love doing trainings in San Diego County with different groups and jurisdictions. So fantastic to be here. And we'll go ahead and cue up the presentation. All right. And again, I know we have a big group, so there'll probably be questions. I know it's a diverse group, so if you could type them in the Q&A or the chat, we'll get to it. We'll have plenty of time at the end to cover everything. But here's basically what we're going to cover today. I want to educate everyone on the Reduce the Risk campaign, how it started, what the background of the whole program is. We're going to dive into some statistics, some statewide gun violence statistics, as well as San Diego County specific statistics that I think you all find pretty interesting. We're going to cover protection orders in our county, kind of situations where they can be applied. We're going to kind of do a deep dive. Alyssa will be covering this into gun violence restraining orders. Again, this is a protective order that's relatively new, but in fact, today is pretty much the 10-year anniversary. The Department of Justice, just hot off the presses, and I haven't read it yet, issued their 10-year report on gun violence restraining orders. I'm super excited to read it. It's basically an analysis of from day one when they started in 2016 to today on how they're applied, statistics, et cetera, across the state. So I can't wait for some light reading later on. And then we're going to cover how you all can get involved in this process. So about this campaign, so this you had some money appropriated from the state legislature back in 2022 to the Governor's Office of Emergency Services. Gun violence prevention is very top of mind at the state level, of course, and this went into an entire program, basically an education and outreach program. A lot of people are familiar with some of the top protection orders in the state, such as domestic violence restraining orders. But gun violence restraining orders in particular, I really think they're not well known. They're not widely used throughout jurisdictions throughout the state. So we go up and down the state, educating all sorts of agencies, small jurisdictions, very large jurisdictions, about what they are and how can they be applied. Also, before this launch, there was extensive statewide studies that went into this on public awareness. And there's actually two advisory councils at the statewide level. There's our Champions Advisory Council. This is comprised of law enforcement, the judicial system, some attorneys, as well as public health officials. And we also reach out to youth. So we have a youth advisory council as well. These are young adults with experience, unfortunately, with gun violence in their lives, who are really, really advocates for this program. So we appreciate them serving at the state level. But really, three simple goals: save lives by reducing firearm violence, both mass violence as well as suicide risk. We'll cover that in depth later. Keeping our communities safe. These are tools that can be applied in many different situations. And basically awareness, public awareness. Let's get this information out. I hope all of you can share some of this information with your networks. The more Californians that know about this, the better. So we're going to play a short video here. If you all remember, I remember this very well. This was one of the first instances of mass violence that I dealt with at my time at Cal OES. But we have the Undersheriff of Santa Barbara County Sheriff's Office, Brad Welch, talking about an instance in Isla Vista.
My name is Brad Welch. I'm a Chief Deputy Sheriff for the Santa Barbara County Sheriff's Office, in charge of our law enforcement branch. I've been with the Santa Barbara County Sheriff's Office since 1999, proudly serving our communities for the last 26 years. The night in question was May of 2014, and an individual named Elliot Roger, who was formerly a Santa Barbara City College student who lived out in Isla Vista, conducted what he called his day or night of retribution, in which he drove around the Isla Vista community, committing murders and mayhem by running over people with his vehicle and using multiple firearms and striking multiple subjects, killing some of them. And this is after he had already murdered his roommates in their apartment. And so this continued for about 12 to 15 minutes until deputies were able to engage him in multiple officer-involved shootings, and he was struck and then ended up taking his life. A lot of people call the Isla Vista incident the icing on the cake, kind of the last incident that really led our legislators to enact the gun violence restraining order. Law enforcement had visited this individual a few months prior on a check the welfare call, and we didn't have the tools necessary to enter the subject's house and take his weapons that were inside the residence at the time. The GVRO, or the gun violence restraining order, had that been in play, could have been a factor that we used. At that point, we only had deeming somebody a danger to themselves under 5150 of the Welfare and Institution Code, and that night, that individual did not meet that criteria. So per the constitutional right, the Fourth Amendment right for unreasonable searches and seizures, we couldn't enter his residence and seize any firearms. The GVRO would have absolutely been a tool that we would have considered using that night. The deputy sheriffs in our law enforcement branch use criminal protective orders, emergency protective orders, and gun violence restraining orders almost on the daily basis, if not a weekly basis, out in the field. We receive tons of calls for service, including domestic violence incidents, but also calls for potential school violence, or those that are in crisis that are threatening harm upon themselves, their family members, or individuals in the communities. And so our deputy sheriffs are being extremely proactive in identifying who is potentially at risk and who should not have access to a firearm, and are writing gun violence restraining orders, petitioning the court, and at most times getting approved, and we're removing those guns from those individuals and preventing them from buying them in the future, which at its core is reducing the risk of gun violence in our local communities in Santa Barbara County.
So yeah, that Isla Vista shooting really was the tipping point for this legislation. I remember that well. You know, you had 6 fatalities, I believe, 14 injuries, got a lot of headlines, and then that prompted the legislature to pass into law the gun violence restraining orders, went into effect in 2016. So the next slide, this slide will just, this is, I always encourage people, if you deal in orders, to print this out, you know, post it in your office, but it's just a nice snapshot of the 9 different protective orders that are utilized statewide. Some are more commonly used than others, so I'll briefly just go into them. So these are the top 4 pretty much always. These are most common. Pretty much everyone knows about domestic violence restraining order. These are folks. This is a close family member, a partner, a spouse that seeking protection from abuse or violence from that partner or family member. You have your civil harassment restraining orders. These are for cases of stalking or harassment. Not closely related to the individual, don't need to be in a relationship with somebody, but that's where that civil harassment order comes in. You have your more general emergency protective orders. Now, these are very, very short term. These are 7 days in length. They can only be requested by law enforcement. These are kind of that immediate Band-Aid. You know, maybe another order might fit longer term, but if you need some immediate relief, those emergency protective orders are a tool to use in those situations. And then criminal protective orders, or CPOs. These are pretty common, issued by judges to protect victims or witnesses of crime. And these other 4 are still used, but not quite as often in the state. You have your elder and dependent adult abuse restraining orders filed on behalf of the seniors or adults 18 plus facing disabilities that can't not necessarily protect themselves against harm. You have your juvenile restraining orders. These are typically filed by probation officers or social workers. These can seek protection for or from a juvenile under the care of a court, so they can really be applied both ways there. You have your post-secondary school violence restraining order. These are filed by the schools themselves. Now, these were for private colleges, universities, or vocational colleges. However, this year there was new legislation. I'm not sure why they didn't do this in the first place, but there was a Assembly Bill 2096. These post-secondary school violence orders now apply to public universities and colleges, so not just private. So that did widen in scope. And then finally, you have your workplace violence restraining orders. These are filed by employers protecting employees and or volunteers or contractors from harm as well. And we'll do a deep dive. Alyssa will cover the gun violence restraining orders in detail. But really quickly, the gun violence restraining orders, out of the other 8, tend to be the least restrictive. have the lowest burden of proof to get one of those issued by a judge. And I'd like to say, when in doubt, you don't know what order is appropriate for the situation. With the gun violence restraining orders, I would stress to focus on the behavior itself rather than the relationship. For instance, domestic violence, that's a relationship. Elder dependent adult, that's a relationship. Juvenile restraining orders, that's a relationship issue. But the gun violence can really be versatile and applied to different situations. So focus on that dangerous behavior when in doubt versus the relationship. Okay, want to cover some statewide statistics in California. So we are the most populous state, as you all know. Over 39 million people live in California, but we have some pretty strict gun laws on the books. We have, mandatory background checks. We've got safe storage laws, the mandatory waiting periods before a firearm can be issued. So given that we're the most populous, frankly, it's pretty good that we're the number 45 out of 50 in overall gun rate, death rate in the country. So considering per capita, that's not bad. We account for 7% of all firearm deaths in the country. We rank 29th in homicide rate in the country and 44th in firearm suicide deaths in the country. So given our population, again, we're doing okay, but at the same time, each year we have about 3,200 Californians dying per year to gun violence. So when you really break it down, that's like a 9/11 scale type of loss each year. So again, one is too many. And out of all firearm deaths, this is really how it's broken down in California. So the majority, you see 54% are suicides. That surprises a lot of people, followed 43% by homicides. And the rest, just about 1% and less than 1%, in fact, are from mass shootings. The mass shootings get all that media attention, constant coverage, a lot of attention, but in actuality, they're less than 1% of all deaths. So really focusing on that suicide and homicide is a big focus of this campaign. And these are pretty telling statistics as well. If you live in a household with a firearm, especially a handgun, the likelihood of harm goes up exponentially. You have 2 times as likely to die by homicide if you're living with a handgun. Adult males who own handguns, 8 times more likely to die from firearm suicide than those that don't. And then women, look at this, 35% more likely to die of firearm-related death than women who don't own a handgun. So you see just the proximity and ownership of firearms, that risk just goes up dramatically. Okay, San Diego County specific. We are the second most populous county in the state with about 3.3 million people. And here's how they break down orders on the next slide of the type. And this changes throughout different counties, but statewide, you see your criminal protective orders and domestic violence just about tied at about 33% and overall in the state, followed by those short-term emergency protective orders at 17%. Then you get into the civil harassment. So your bottom four really are the elder adult, the juvenile, the gun violence restraining orders, and then those workplace violence at the bottom there. So you see with less than 1%, the gun violence restraining orders, we do feel that's low. And then so we're trying to hence raise the awareness that, hey, these are good tools to use if the situation presents itself. And here's how it stacks up. So it doesn't necessarily purely align. And again, those top four, very consistent throughout the state, although they may differ in ranking. But you see, these are per capita stats, so issuances per 100,000 people. So you see domestic violence restraining orders clearly at the top, followed by the criminal protective orders, and then the civil harassment, and then the emergency protective orders. Now, we do see the GVROs, gun violence orders, at 15 per 100,000. That's not bad. And I will have to say, probably the first 5 years that the GVROs were in law, San Diego County and Santa Clara County, just those two counties filed over half in the state. So I will tell you this, San Diego County, it may not feel like it, you may not be aware, is, I would say, going all up and down the state, is the leader in this. So there's been a lot of work dedicated countywide. City of San Diego's done a great job at launching these programs, using them in real life. So I think that's a big kudos because we have seen some really best practices down here in San Diego. So it's fantastic to see. These are 2024 stats, and then we did see all protective orders decrease by 4%. No trend. No, we're not seeing any trend, rhyme or reason for ups and downs year over year, but just from 2023 to 24, we saw a slight decrease of 4%. Still waiting on the 2025 numbers from Department of Justice, but I'm hoping to get those pretty soon. Okay, as we mentioned, yeah, a lot of research went in before the campaign was launched on what does the general public know about these types of orders. So what we found was 70%, or 7 out of 10 of Californians, believe that yes, the state has some type of laws on the books restricting gun ownership or possession. Again, 70%, most of Californians, and I'm not surprised, I thought this may be higher, know about domestic violence restraining orders. So generally speaking, most people are aware with the domestic violence orders. But only 30% knew that the gun violence restraining orders even existed. Very, very little awareness in GVROs. But of those polled, almost 80% were concerned that, well, why don't we know about these? And again, it's not just law enforcement or the judicial system that needs to know about these, it's the general public. Alyssa will cover it later, but there's members of your family, your partner, your roommate, they are eligible to file for one of these orders. So not a lot of people know that still to this day. And as you see, that 77% figure said, yes, if we did know about this and were faced with a potentially risky situation, they would consider filing one themselves. So interesting statistics there. Next, we'll play a short video because suicide prevention has been very effective with GVROs. We're going to hear from UC Davis, Dr. Amy Barnhorst, on her experience with these.
I'm Amy Barnhorst. I'm a professor of psychiatry at UC Davis, and I'm the associate director of the Centers for Violence Prevention. So when people think about gun violence in the US, they often think about mass shootings because that's the thing that's all over the news and the media. And we think like, wow, this could happen to me anytime, anywhere. I could go to the school, I could go to the mall, I could go to church, I could go to a movie theater, and this could be me. But the truth of the matter is that mass shootings represent 1% or less of our firearm deaths in the country, depending on exactly how you define them. And the majority of firearm deaths are actually suicides. So GVROs can be helpful for somebody who's in sort of the acute immediate crisis, but also in that crisis period where it's a way to remove the person's firearms that they already have and then also prevent them from getting more firearms so that they can get through that crisis period, however long it is, without guns at the ready and hopefully survive it and come out of it and get a second chance at life. A lot of the warning signs for people who are in crisis are the same, actually, for whether they're at risk of hurting themselves or somebody else, or potentially both. So one of the precipitators often is some kind of big loss of a job, loss of a parent or a family member through death, loss of a relationship through a breakup, financial loss, legal losses often can be precipitants, where they throw somebody into this sort of crisis spiral. And then if that person who's, everything has kind of fallen apart in their life and emotionally their reaction to it is also just, very catastrophizing, then they may in that dark moment think, oh, I don't want to do this anymore. I don't want to be around, and reach for what they have at hand. And if that's a gun, they're not going to get a chance to find out, like, oh, actually, there's another job available next week, or to reconcile with their partner, or to find out that, hey, their sister thinks it's fine if they come crash with them for a while. Like, they don't have a chance for things to get better. The collaboration between mental health and law enforcement is really important, not just in reducing risk from threats of mass violence, which is one aspect of it, but also in addressing suicide, because law enforcement officers are often the first responders when somebody calls 911 saying, I'm suicidal, or my son is suicidal, or my partner is suicidal. They're the ones who go out there. So they have to have skills to de-escalate and know exactly what pathway to take, especially if it's going to be a while before a mental health professional can get involved. A lot of folks who are firearm owners are really concerned that they won't ever be able to buy guns in the future if they have a gun violence restraining order filed against them. And it's important to say, like, I recognize how much guns are a part of your life and your identity and what you do, but this is a civil order and it's time limited. And while you won't have guns for the period of the order, or if you file an order on somebody in your community that you're worried about, they may not have guns for the period of the order, but it does preserve their Second Amendment rights after the order is lifted. Unlike, for example, if they do something really rash and violent and they have a felony charge, now they are prohibited from owning firearms for life.
Yeah, Dr. Barnhorst has been a huge advocate for this program. And when we first launched, there were really two target audiences for this program. It was law enforcement, because they are involved every day in filing these and serving these. And it was really public health, specifically behavioral health, because of the suicide risk, and they're on the front lines of this, can see people, can see the signs. So those were really our first two target audiences. In 2026, we're kind of expanding our reach. We're reaching out to victim advocacy groups, more so to schools, some community-based organizations, as well as veterans organizations as well. So we're just expanding our outreach this year. But as she said, mental health crises can be temporary. You can get your treatment, you can move on and recover. So the gun violence restraining orders are just that tool, that one little tool that may make that difference in saving a life. And I didn't know this either. More than 40% of suicide attempts occur 10 minutes from that first thought of self-harm. So they're very impulsive, So 10 minutes, make that decision. And when it comes to a firearm, that's just too quick, and you don't have time to regroup. So that surprised me. And again, we saw the statistics about owning a handgun. It increases over 3 times for all suicide risk compared to non-handgun owners. So again, these can be versatile tools, prevent self-harm, prevent domestic violence, potential mass shootings. So very versatile tools. And what we're tracking here overall, we've tracked that about 58 potential mass shootings have been prevented with the issuance of a GVRO. Again, you never know if somebody will carry something out, but all it takes is one. So that's what we're tracking in terms of mass shooting prevention. Now, the second stat it's only for about the first 3 or 4 years. I don't think it's tracked as closely as it was. But for the first 3 or 4 years with this program, 0 suicides have occurred among the individuals served with the GVRO. So that's a fantastic result. We're very proud of that. Again, we don't know probably the last 5 years of data, but in the early days of the issuance of these, that was a fantastic thing to see, because 40% of all GVROs served address suicide risk. So again, very successful. There are about 20 states plus Washington, D.C. that have similar laws on the books. And collectively, we're seeing about a 14% reduction in suicide rates amongst those states with similar programs. And again, you don't need necessarily a criminal mental health evaluation or history. With the low burden of proof standard, you could have something like threats on social media, texts, videos, things like that, even hearsay, so that one of these can be granted by a judge to prevent harm. So again, very versatile tools. This is a pretty famous study. I know it's old from 2017, but Connecticut was one of the first states to adopt one of these gun violence restraining order programs. You have a CDC figure that every day in the US, about 230 people are injured by guns and about 90 pass away, 60 of those from suicide. So you see that's very, very high nationwide. And I didn't know this either. 90% of people who attempt suicide survive. So that could be, not necessarily from a firearm, from an overdose or what have you. But if you use that firearm, as Dr. Barnhorst said, you may not get that second chance. Only 9% that use a firearm survive. So again, it can be that impulsive decision, and that's not a very high survival rate at 9%. And then Connecticut, some academics crunched a lot of numbers. I can't tell you the formula they use, but they have estimated that for every 10 to 20 firearms that were seized in Connecticut, averted one suicide. So that's kind of the math that played out there. So again, you see the effectiveness in practice. So I'm going to pause there. I know that was a lot, but I'm going to hand it over to my partner, Alyssa, to do a deeper dive into GVROs.
Thank you, everybody. Can you hear me, Jeff?
Yep, gotcha.
Okay. Thank you, everyone. My name is Alyssa Gutierrez. I didn't get a chance to do an introduction at the beginning, but just really quickly, I did work with the California Highway Patrol for about 9 years as a law enforcement officer. I did a lot of PIO stint there about for 4 years. And after that, I was able to kind of go into the private sector. So I'm really excited to be here and to continue training you on these gun violence protection orders. So moving forward, one of the big issues that we deal with the GVROs, especially when we go and train on law enforcement, is there's a lot of myths and that we really want to debunk before we get started. So one of the biggest myths that we hear is that the protection orders they seek to remove guns from law-abiding gun owners, and this isn't true, right? We're really trying to just save individuals who are in a mental health crisis from hurting themselves or potentially others. So it's not a gun grab. It's not something that law enforcement likes to do to take away guns from law-abiding citizens. It's really just a safety measure that are put in place to give people a pause and a timeout to get the help that they need. Another big myth and issue that we've had come up in our trainings is a danger of retaliation. Retaliation, it's something that people worry about when they do file these as a petitioner. And I'll get into that a little bit more as we go on. But there are some processes in place to help mitigate the retaliation risk. And another myth is serving protection orders is complicated and includes too much paperwork. And that's just not true. The amount of paperwork that goes into it is about a page, maybe a page and a half, depending on how much information you can provide the judge. So it is relatively short, but we do need to make sure that we provide enough burden of proof so that the judges who do receive these GVRO applications can make a sound judgment when they do accept the GVROs to be filed against that individual. And just some of the facts, like I said, these GVROs, they are temporary, so it does preserve an individual's Second Amendment right. So they won't remove the gun from the individual for, a permanent. It's going to be a temporary, about 21 days, but we'll get into that a little bit later on. And then the protection orders can be sealed and be used as investigative tools to help law enforcement continue with investigations. And then the process about too much paperwork, it actually follows the same process as a DVRO. So just as a domestic violence restraining order, there's not too much paperwork that goes into that, but we will also see how long that paperwork goes in the next couple of slides. So what is GVRO? I know Jeff had gone over a couple of different protection orders earlier, but let's get into a little bit of a deeper dive of the gun violence restraining order. So a GVRO lets people, families, teachers, spouses, anyone who knows someone who's in a person in crisis, so mental health crisis, they actually can be a petitioner for this. So this isn't something that needs law enforcement that needs to come out to do this. This is something that if you know someone who is close to you, you have enough information that you're afraid for this individual and for their health, and that they may have access to firearms within their residence, you can actually go in and file this in any law enforcement agency or court where they have the necessary paperwork. You can go in and file this information and to send it to the court and hopefully get it signed off by a judge and sent back to the law enforcement agency within that area so that GVRO can be issued in for that person who's an individual in crisis. So this helps protect everyone. You know, it helps people have a tool that they can use and not only having to call law enforcement to do this for them, they can actually do it themselves. So this is one of the few protection orders that an eligible petitioner can actually initiate themselves and not needing law enforcement to start it for them. So how this helps, a GVRO actually takes away someone's gun for a short time so the person can pause and get help. But they also aren't allowed to buy guns. So even if the individual doesn't have a firearm registered to them initially, they actually will be mitigated from being allowed to actually buy firearms or magazines if that GVRO is actually filed. And then how long do these GVROs last? A temporary GVRO initially provides protection up to 21 days. So I think Jeff mentioned with those EPOs, those usually last about 5 to 7 days. So it's really relatively short term. With the GVROs, the initial filing will actually last 21 days. So we're really hoping to push these whenever it is applicable in the situations, just because it gives that person a little bit of a longer timeout to get the help that they need. And then the petitioner can always refile for an extension for 1 to 5 years. So just providing a little bit more information to the judge, they'll be able to help extend this as long as they have enough burden of proof to say that the extension is needed against that individual. So these are some of the applications on reasons on why someone might file a GVRO, family violence or stalking, substance abuse, threats of suicide, mental health issues, including dementia, PTSD, trauma, and threats against schools or workplaces, social media threats and violence, mass violence or domestic terrorism. And social media, you know, that's a big effort between all the school age kids and high school age kids. And so this actually comes up a lot in the GVRO. So we're really hoping to push this information to the educational space, like Jeff had mentioned, so that we can let students know the signs that they need to look out for when their peers are, you know, demonstrating some of these behaviors so that they can tell an adult to get that mitigated. And so, like I mentioned a little bit before, this is going to be a video on high school age situation. So this is a principal, Hans Becker. He's from the Rancho Bernardo High School in California. He's going to talk about how they use a GVRO to help mitigate a potential tragedy at his high school.
My name is Hans Becker, and I'm the principal at Rancho Bernardo High School. I've been a principal at Rancho Bernardo for 5 years. Before that, I was the principal at Point Loma High School for 7 years. So the incident that led us to filing a GVRO, it was the winter of 2024 that we had some students come to the counseling office and report that they had heard a student saying some things that were scary and also showing some videos of that student using firearms. Those students did the right thing and came to our counseling office. After the counselors had heard this, they immediately came to my assistant principals and then my office. At that point, we decided to call law enforcement and then contact the student. So the time frame of when I learned about the threat to the GVRO being served was a matter of hours. We learned about the threat probably around 2 o'clock in the afternoon. School gets out at 3:35. We had law enforcement here before then, and we were here till about 6 that evening with the student and law enforcement. And by that evening, the police were at the house. What do I think if a GVR was not filed? It's hard to imagine, but I know that it would be, at the very least, very scary to continue coming to school every day, especially for the students that saw the things that they saw and reported the things they reported. So one of the points that I want to really emphasize here is that it's important to have a school culture where students feel safe and empowered. We were fortunate to have students that felt brave enough to come to the office and report things they knew should be reported. And then after they were reported them, we followed with action.
So, like Jeff had mentioned earlier, less than 1% of gun violence situations are attributed to mass shootings, but the amount of media coverage that mass shootings get is actually astronomical. And so, high schoolers and middle schoolers are exposed to this type of media, but it gives them the tools to recognize, hey, this behavior doesn't seem right. I think this person might be an issue, just like Hans Becker had mentioned. So they're able to recognize those signs and tell adults and principals and let them know, hey, this situation is not right. So I like to say it's unfortunate and fortunate for the amount of media coverage that mass shootings get, but it helps potentially mitigate threats like this one. Okay, so let's go a little bit deeper into the types of GVROs. So one of the types of GVROs is emergency protection orders, but it's an EPO 002. So Jeff had mentioned the EPO earlier, but a normal patrol officer will carry an EPO 001, and that's a person-to-person stay-away order. So this specific EPO 002 is for a gun violence emergency restraining order. So this is something that would be filed on scene. So a law enforcement officer is the only one that can file this type of GVRO. And it is presented to a person in crisis that poses an immediate danger to themselves or others. And this EPO 002 will last 21 days. So it'll be exponentially longer than that normal 7-day period that an EPO 001 would give. And then moving into the temporary GVROs, a GV110. This is the form that a petitioner will fill out. So this can be a non-law enforcement petitioner. This is just someone who is close to an individual in a mental health crisis. Just if they have enough information to substantiate, hey, my son, my brother, my spouse is having a hard time. I'm afraid they might grab, a firearm within reach to hurt themselves or others, or they've been saying certain things. So this is for someone who just has that type of information against this individual to be able to present that to the judge to hopefully get a GVRO filed. With these will also last 21 days, but the the process takes a lot longer. So it's not an emergency protection order. It's something that'll be take a few days to get filed through the judge and then back to the law enforcement agency where that person resides. So it's a great tool, but it does take a little longer than a normal EPO. One of the bigger issues that we've dealt with for the petitioners, on the petitioner side anyways, is being afraid of retaliation. And, rightfully so, right? If I have the father of my kids, he doesn't like me, I don't like him, and I'm afraid he might hurt me because he has access to firearms and he said, certain things. So me, as someone who's close to that person, I'm afraid of retaliation, right? I don't want I don't want him to come back and know that I'm the one that filed that GVRO against him. Right? So with that, there is some processes in place. If I were to go to the judge, I could tell the judge, hey, this is a reason why I feel this is a safety risk. I don't want my name on this GVRO when it's filed because I don't want, so-and-so to know that I filed it against them. Right. So when you present that safety risk to the judge, they can seal the name of the petitioner, but it will not automatically be sealed. So they do have to present this information to the judge so that it can be sealed, or else it will be on there if they file a GB110. Now, if the law enforcement agencies are called on scene and it is filed as an EPO 002, that petitioner's name won't be on it. It would be the law enforcement officer who would have to substantiate why they filed that GVRO on that person. And once these GVROs are entered into the CCPOR website, it does become public record, but the only information that goes on the public record would be the individual where the GVRO was served against, not the petitioner. Okay, one of the big questions that we do get, especially with our law enforcement audiences, they ask, what's the difference between a 5150 and a GVRO, right? There is a lot of fine lines in between both. It kind of gets a little misconstrued going into it, but let me give you some insight on the 5150. So a 5150 is a 72-hour involuntary psychiatric hold. That means someone that is experiencing a mental health crisis can be called on by a mental health clinician, a medical professional, or a law enforcement officer. And if they deem them these three things, it would be, one of these three criteria. So it would be a danger to themselves, a danger to others, or gravely disabled. So if any of those three different types of professionals can say this individual, is one of those three, then they can be involuntarily put on a 5150 hold. And so a 5150 hold will be held up to us. A person will be admitted for about 72 hours, and that's for evaluation and support. So if someone is placed on a 5150 hold involuntarily, then the law enforcement agency can seize firearms whenever that ends up getting issued. Now, if a medical personnel does do the filing on the 5150, then it would be their jobs to let the law enforcement agencies or um, the caseworker know that they need to have these firearms removed from the individual, and that's only in the case where someone knows, a medical professional knows that this person actually has firearms in their homes. It may not even be public information to them. So it is a little different in the GVROs, but I'll give you a little bit of a comparison in the next slide. So this is a 5150 hold versus a GVRO. So the 5150s are for immediate mental health crises. Firearms may temporarily seized if the person in danger. If the person is in danger, the firearm ban only applies for individuals that are admitted to the facility on an involuntary hold, and that firearm prohibition will be for a 5-year term, and it will act immediately once this person gets put into the psychiatric evaluation. So it is immediately starts for that firearm prohibition. And then in comparison to the GVRO, this is used to prevent firearm related harms. And this is a civil court order. And you can see the penal code section here. And then it requires a firearm surrender within 24 to 48 hours. And so with that civil court order, so law enforcement goes to actually serve this GVRO to this individual, and they say, hey, Mr. Smith, you have a GVRO filed against you. We like to take your firearms. Now, if that individual decides, hey, I don't want to give up my firearms, it's a civil order, so there's not much that law enforcement can do at that point. So they would have to go back and file a search warrant with the judge and let them know the situation and see if the judge would sign off on a search warrant to get those firearms removed. And then, like I mentioned, this is a temporary order, and the full extent to this order can be 1 to 5 years, but that's only if an extension is filed and approved by the judge. Now, here's a real world example that we have for you. There was a recently discharged Marine experienced psychiatric episodes, and he was suffering from paranoia and PTSD. While he went to an auto repair shop to get his car fixed, he started believing that people in the store were armed and intending to harm him. So he then went back to his vehicle in the parking lot and retrieved a pistol and came back with the pistol placed in his waistband. A witness at the shop then called law enforcement. Law enforcement responded and filed a GVRO in response to the situation. So with that information, you have this person experiencing these certain challenges, psychiatric challenges, and just the information with what the police received from the witness, they were able to file that GVRO and to provide that burden of proof. And now we're going to talk about a little bit how to file. I mentioned that, the term burden of proof a couple of times already, so let's go over it a little bit more in depth. So for filing GVROs, reasonable cause that an individual possesses a significant threat to themselves or others. So this can be something like alarming behavior, erratic behavior, suicidal statements, behavioral health reports, substance abuse, verbal threats. But with all these different types of behaviors, this person doesn't have to have a behavioral health report, right? This person doesn't have to have a clinical diagnosis. This is just something that someone who's close to them can say, hey, I've seen these types of behavior. This does make me afraid for this person's health and safety. So it doesn't need to be a clinician's health report. It's just another option if they were to put that in that GVRO filing. Another example would be statements on social media, so text messages, images of firearms, or recent firearm purchases. And then to substantiate a long-term GVRO court hearing, the individual, so either the petitioner or law enforcement, would have to go back into a court hearing and establish, clear and convincing evidence that the threat is still present. So that 21 days wasn't enough. I still think that this individual can use a little bit more help. And so they have to establish some convincing evidence to the judge to say, hey, I think this person needs to have a longer time frame without their firearms. Patterns of violence or chronic mental health concerns will help this case. And then escalating threats of violence or suicidal thoughts and documented threats will help this case be extended. So police reports, witness testimonies, pictures, and then any just physical type of evidence will really help this extension be approved by judge without having any issues. So this is how you would file an EPO 002. This is specifically for law enforcement. Like I mentioned, only law enforcement can file an emergency protection order, or sorry, emergency gun violence restraining order. So they would be called on scene, either due to a suicidal subject or some other situation, and they would have to establish, enough information so that they think, hey, this person can be a risk to themselves or others. They have access to firearms, or if they may have a plan to go get firearms. This is subjected to the officers on scene. They would then call an on-call judge and let them know all of the information and the burden of proof that they have. And if the judge deems that it's enough, they would sign it off on scene and serve that immediately. Now, the steps to file a GB-110, so this is a little longer. So this is for these eligible petitioners. So this is a non-law enforcement petitioner. So the first step would, to go to either the courthouse, or go to any law enforcement agency that has the GB-110 forms. They would fill out the forms with much information as possible to establish that burden of proof. Next, they would give it back to the law enforcement agency. That law enforcement agency would then send it to the Superior Court Clerk. That court clerk would then send it to the judge, and when the judge would make their decision on if they think that this GB-110 needs to be filed. And if they do deem that it needs to be filed, then the judge would send it back to the law enforcement agency, and then they would end up going to file that and serve that petitioner within their residence. So they would have to go to the law enforcement agency within that jurisdiction to get that filed and served. So as you can see, there's a lot more steps on the GB-110 in comparison to the EPO 002. So it does take a couple more days. So this is something that you could use when you think that maybe there is, some time so that this can get the process done and that the judge can sign it off and send it back. But you have to know as a petitioner, it's not going to be immediate. So it's something that's going to happen through a couple of days. Now, if the situation, it depends on the situation. If it's a little bit more emergent, then possibly calling law enforcement to file that EPO 002 might be a better step for you in that case. So here's the firearm surrender process. I kind of mentioned and talked a little bit on these already, but following the GVR service, the respondents shall not possess or own or purchase any firearms, and this prohibition applies immediately. You must comply within 24 hours of being served. Surrender your firearms to law enforcement, or you can sell or change possession from a firearm dealer. And then after all of those firearms are actually surrendered, you have to file a receipt of surrender with the court within 48 hours of that initial service. And then when an individual fails to surrender, a court may notify prosecutors or law enforcement. And if the law enforcement has probable cause of firearm possession, they can seek a search warrant to recover them. So they have to go back and present more information to the judge to let them know, hey, I think this person does have access to firearms, and then they could get the search warrants actually signed off and then served. And then the restrictions apply to the respondent only, so not necessarily other household members. There was an appellate court case that just got overturned where there was an individual, I think he was under the age of 18, and he had access, or I think it was a son and a father, and the son was the one that got the GVRO served against him, and the father was fighting not having his firearms taken away, and I think they just overturned it so where they did take the father's firearms away. So it can go both ways. There's a lot of changing legislation, and we'll get into those slides in the next couple of decks. Before we get into that, though, we're going to be hearing from Sergeant Kyle Akiuchi. He's from the Sacramento County Sheriff's Office, and he's going to talk about how he files a GVRO from start to finish.
I'm Kyle Akiuchi. I'm currently a sergeant for the Sacramento County Sheriff's Office, and prior to my promotion, I was a threat management detective. For law enforcement to initiate a GVRO, first thing we're going to do is get the information. Once we get that information, we're going to go through and determine if there's any credibility to it or any high concern. Once that's been established, at that point, law enforcement will file a gun violence restraining order with the courts. So they will file a simple piece of paperwork, contact the on-call judge. At that point, if the judge agrees, they will sign it, and law enforcement can execute that gun violence restraining order. Once a GVRO is obtained and signed by a judge, we have to submit it to the subject. If the subject is non-compliant with surrendering his firearms, the next process would be obtaining a search warrant. That's also a fairly easy thing for law enforcement to obtain, especially in the circumstances of a GVRO. Once a search warrant is authored and signed by a judge, that now allows us to go into the residence and remove any firearms, ammunition, or anything else that is listed in the search warrant. Although there is a process for doing it, each county might have a little bit different twist to it, and therefore it would be beneficial for those agencies to speak with their DA's office and their courts to make sure that they're filing them correctly with them. Most people would assume that they're complicated, that GVROs are complicated, even though they are not. They're probably also concerned that they may be potentially taking firearms away from a law-abiding citizen. However, the process of a GVRO kind of eliminates that, where we have to provide a burden of proof that, hey, there is concern here that this person may cause serious bodily injury or death to themselves or others if we do not take away these firearms. And that's not an easy burden of proof. So we have to make sure we come with all of our stuff and all of our information prepared. And at that point, it's kind of one of those calls for service where the little hairs on the back of your neck are standing up and saying, hey, something isn't right and I need to do a little bit more. And this is one of those tools that can help you do that little bit more.
So like we mentioned, that GV110 is this really short form. It's potentially just a one pager. There's a couple of empty boxes on the back that you can actually fill out just to provide enough information to just give enough information for the judge to substantiate, hey, this person does need this GVRO filed against them. And then if you look through these EPO 002 form, it's actually a little shorter just because there's a lot of wording on top. But this is, this is an emergency gun violence emergency protection order. So in comparison to those EPO 001s, the EPO 01s is a stay away order. So this EPO 002 is not a person-to-person stay away order. So you cannot use this form for that in that situation. So we're just making sure we're really trying to give this information to DA's office and law enforcement agencies to let them know, hey, when it is applicable, please use this form because it does last a lot longer than a normal EPO. So in comparison to that 7 days. But if an officer uses an EPO 001 and they end up going back to the office and saying, hey, this might have been a situation to use an EPO 002, they can't file concurrently. So they have to file one or the other. So just making sure we're using this when applicable so that we can use it for the longest amount of time that we can, whenever, like I said, it is applicable for the situation. Now we're going to go into a little bit more about law enforcement. Even though this type of gun violence restraining order can be initiated by a petitioner, 98% of the GVROs that were filed statewide from 2016 to 2023 were filed by law enforcement. So this is just that information, that public information push that we're trying to do with this campaign, is just to let people know that, hey, they can seek these without law enforcement's help, but law enforcement is going to be one of the most petitioners that we do have statewide, and they're going to be the ones that will file these amongst most of the individuals that actually file GVROs. Like I mentioned a little earlier, law enforcement officers are the only ones that can seek those emergency GVROs, so those EPO 002s. And then individuals who know someone is in danger or themselves or others may prefer to work with law enforcement. Like I mentioned with that retaliation issues, sometimes they would prefer law enforcement to be the ones in that buffer between them and the individual that they may know have a mental health crisis. And then, like Jeff mentioned a little earlier, San Diego has a really robust program. You guys are doing a great job down there in getting a lot of these GVROs filed. San Diego is one of the ones that kind of initiated this whole campaign and really streamlined the process. So next we'll be hearing from former City Attorney Mara Elliott to talk about how they streamlined this process down in your county.
I'm Mara Elliott, former San Diego City Attorney from San Diego, California. I decided to start a GVRO program in our office back in 2017. And the reason was really in response to what had happened at Sandy Hook. And that was, I think, the first time I felt very shaken. I think there was always a sense in me and a lot of other parents that schools were sacred areas and our children would never be subject to that kind of violence. But after that shooting in 2012, and my children were roughly the same age, I really felt compelled to do something. We created our program one step at a time because there was not a model in the state of California that we could follow. We can't say we were the first to ever obtain one. We just couldn't find a program that was going to really embrace this tool and use it to protect communities. We needed law enforcement because Although we might get a phone call to say, hey, we've got some concerns, maybe from a nonprofit or a concerned community member, law enforcement is usually the first point of contact for somebody who's concerned about someone they care about, or from a person who is also at risk. For instance, somebody who's contemplating suicide. So having law enforcement available and knowledgeable about what the law said was extremely important to us. We needed to train them because they're always learning something. The laws are always changing on them. So when can you use a gun violence restraining order? What does the court need to see so that they can issue a gun violence restraining order? How do you do your job? How do you serve it? How do you work with other agencies in the region so that we're all on the same page? And once we have an order, how do we ensure that it's implemented? So we had to start by training our own. And that relationship eventually evolved where we had law enforcement stationed within the city attorney's office because it became seamless that way. We had professionals who just knew it, knew the law inside out.
So like Mara Elliott mentioned, there's a lot of laws that change, and that's, that happens year to year. So here's some of the examples of our new legislation regarding GVROs. And then one of the biggest goals is making sure that this process is consistent throughout all of the counties in California. So this Senate Bill 899, Firearm and Ammunition Relinquishment Enforcement, it strengthens and standardizes firearms and ammunition surrender under GVROs and the protection orders. Courts must confirm surrender receipts or sale of firearms, and if proof is not provided within 2 days, courts must notify prosecutors. So this is a new bill that helps confirm the surrender receipts, which didn't have to happen before. So I think this will really help maintain the consistency of making sure that these are actually filed and served. And if that person does want to end up giving their firearms, 24 hours to 48 hours later, that we're making sure that it's confirmed with the court that this actually is getting done. And then Assembly Bill 451, Law Enforcement Policies on Firearm Restricting Orders. This requires law enforcement agencies to adopt written policies by January 1st of 2027. So there's a lot of agencies that don't have written policies about this. And so this is going to apply to all municipal police, sheriffs, CHP, and university police across the state. And the goal is to ensure consistency, clarity, and compliance across agencies statewide. And then Assembly Bill 1344, District Attorney GVRO pilot programs. This authorized select counties, so this included Alameda, El Dorado, Santa Clara, and Ventura, to allow district attorneys to file GVROs, petition directly. And this pilot program will run through January 1st, 2032. And this will test whether to expand DA authority and improve GVRO access throughout the state. So we're excited to see the numbers on this and see if this helps implement more GVROs throughout the state and continue this policy, hopefully across all counties in California after this is over. So a little more information about how you can reduce the risk. We really hope that you share this information that you learned today, and we hope you can refer any other colleagues that you know that might benefit from this training. And then you can also subscribe to our updates. And then if you scan this QR code, it'll link you back to our website, and that's reducetherisk.ca.gov. This will give you a lot of information and interactive tools to kind of see the gun situations in your county. You can have downloaded resources there as well. And that is going to be that's going to end our presentation. We're hoping to open it up to some questions. Since I was sharing the screen, I don't have access to the questions, but if you had any, I hope you put them in the chat. Yeah, but we're open for questions. If you guys have any for us, we would love to answer.
Hi, Alyssa. This is Gloria.
Hi.
So we had a question that Jeff responded to in the Q&A, but maybe we can talk about it with the rest of the group. And the question is, are the San Diego courts the source of protective order statistics?
Yeah, so great question. We get them from Department of Justice because we're trying to track every county, so that's our source. Perhaps they vary, locally versus getting them from DOJ, but that's our official source.
Any other questions that people might have? This is a webinar setup, so you can't unmute, but you can write your question in the chat or in the Q&A, and we'll be monitoring that. Jeff, I have a question. So if I'm worried about, let's say, a neighbor that's been acting strange and he's been saying things about hurting someone, and I know he has weapons and firearms in his house. What's the level of concern a person has to have before they reach out to law enforcement to ask for a GVRO?
Sure, yeah, that's always a tough one. It's really the legal burden is, reasonable cause. Is it reasonable to assume this person will act upon those violent threats? So it really would, and then the easy thing to do would be to go to law enforcement first with that information. Again, so if you're hearing constant or escalating threats revolving around firearm usage, so that is the nexus, with the weapons possession, as well as those violent threats, can you document any of that? Your sworn testimony as a witness is part of it. Is there more? Because you remember law enforcement will have to petition the judge. And ultimately, the judge is very, they can be all over the map, quite frankly, depending on what county you're in. But if you prove that reasonable cause, that yes, more likely than not, this person could act out upon those violent threats. I know that's vague and I know that's very subjective, but it kind of depends, what you're getting, what you're seeing, what you're hearing. If you can document it, especially with social media screenshots of that or text, that will strengthen your case. I hope that helps a little bit.
Thank you. We have another question here. Can a GVRO be filed at any court in San Diego County?
So these are filed in the Superior Court. So unless a different court, like a criminal court, has a special program, I'm pretty sure they've got to go to the Superior Court. However, they're trying to make this easier and doing even like some online submittals. I know a lot of jurisdictions have implemented that. Don't quote me on what they've got here locally. I believe that is an option to file electronically, but they're trying to make it easier for people to do it rather than physically going in. That can be intimidating, that can be time consuming. And I think we're going to see more of that as time marches on here, just make that filing process easier.
Wonderful. And we have a comment from one of the listeners in the webinar that says, as an ED physician that has relocated here from North Carolina in 2019, I cannot emphasize how different and effective the gun culture here is and the efficacy of gun laws here in California. This is an amazing program and saves lives, no doubt.
All right.
Thank you.
Yes, wonderful. Welcome to California. So there's a comment in the chat, and it says, I accompanied a senior to get an elder abuse restraining order. He legally evicted a commercial tenant for not paying rent. After the eviction, the tenant and another used a crowbar and hammer to break into his former office. When he went to the EB hearing, the elder abuse hearing, I was not able to help the plaintiff. I was called a friend. And then it says, the elder speaks slowly and hesitates to find the right word. He asked the court if he could hand him his own notes to read to the court. He was told no. So no advocate can assist the elder, which seems wrong. This was in San Diego. So I guess there was the question is, seems like in an elder abuse restraining order, could there be some assistance for those elderly persons who are seeking that order, who may have their own disability, whether it's to speak in front of a court or to, kind of have an advocate that can support that? Is that allowed?
I'm wondering if they wanted a licensed attorney.
Or ordered. So it can't be someone that's just his friend because they don't, it's just not it's not approved through the courts, right? So something that can be court ordered, like a court ordered translator or somebody that's provided by the court, then that would be able to be used within a court hearing, but it has to be either court ordered or an attorney.
But I agree, that does seem wrong, right? You're just trying to advocate and help. But again, it depends on the court rules.
I think we had some individuals get muted.
Yeah, if someone is unmuted and wants to ask a question, I think we could try it.
Diane, did you want to speak up or,
Yeah, can you hear me?
Yes.
Yes.
Oh, good. Okay. The court gave a minimal order, which was really sad. It was 1 year, and he looked at the respondent and he said, "Look, the bar is really low, so I have to give you a year." So, in other words, he was restraining this guy that used a crowbar to hammer and was a history of violence in the declaration and all the moving parties. And he was like pandering. It was awful. And the person I went with, they didn't know what to call us. We asked the bailiff, "Can someone go in there?" Because he's always slow in just his movements. That's his manner of speaking. So it wasn't fast enough apparently for the court. And I thought it was so wrong because we did go to where they have domestic violence, and they said, "No, there's nobody for elder abuse," but we got the forms. But I thought it was so wrong that they wouldn't let anybody. It didn't matter what, they didn't ask me if I was a lawyer, an advocate. It didn't matter. So it was a little dismissive. The judge says, "Okay, she can come up with you, but we'll call her a friend." And I was so disappointed because the facts were so strong and they were documented by several witnesses. And the person he had a history of doing it to other people. And that was in factual, documented by declarations inside the file. And so that person, chances are, after the year is up, is going to come back again. And so there was no belief in this system from the petitioner. It was kind of like, that's it. They're supposed to help elders.
Yeah.
But it didn't matter what the person was. They didn't ask if I was a lawyer or I had a background. I happen to be a long-term domestic violence advocate, and I write state legislation on DV and sexual assault and stalking. But none of that got in front of the judge, but I don't think they would have cared.
Well, I'm sorry to hear that.
Yeah.
It's good to learn this information. Sometimes we can take examples back to the Champions Advisory Council at the statewide level. As this evolves, there could be more legislation. In the future, we've had some cleanup bills that Alyssa went over. So it's always good for us to hear some of this feedback. What I will tell you from speaking with others across the state is we've heard that judges vary dramatically. And it sounds like in this case, you didn't get a very friendly or accessible judge. I heard from, I believe it was San Mateo, who didn't even let the law enforcement official speak. I said, I only want to hear from an attorney, which is completely wrong and inappropriate. because they're supposed to be at the hearing anyway. So honestly, in my opinion, I think our judges, some of them need to be educated a little bit more on this process. That's just an aside. But I'm sorry for that experience, and thanks for sharing that, because it really helps us kind of assess what's happening on the ground.
Yeah, that's the second case in maybe 10 years that I happened to somebody came to me for an elder abuse restraining order. The first one was the same way. And the woman that petitioner, she worked in the federal court's house for 40 years. She was organized, had everything tight, and she was very intimidated by the person harassing her. And the judge, again, it was very dismissive to her. She did not get the restraining order. She ended up having to physically move out of a condo complex because it just kept getting worse for her from the same guy.
Mm.
And so I think if they have restraining order clinics, they should be able to have advocates for anybody getting restraining order, not necessarily just domestic violence. And I don't know if that's something that could be carved off, because I call the elder groups around me and nobody does this stuff. But it would be nice, because they're usually more, they're more unsure of the process. They're kind of uncomfortable about speaking up, because an older generation is used to just going along with the flow and not making a ruckus. And so it took a lot of guts for this person to go to court. So did the other person I helped.
Absolutely.
Thank you very much for that. That's certainly something to keep in mind. There are a few places, like elder law, that provide services specifically to
I called them.
older adults. So, I mean, we could definitely bring these, concerns up, and see what Jeff and Alyssa are in the trenches of this at the state level, to see what can be done.
If anyone, they want to keep my email, because I draft legislation usually every year. This year I took a break, but I would be interested.
Thank you very much, Diane. Thank you for the work you're doing.
If you want to drop your email in the chat really quick, Diane, so I can write that down. Thank you.
I injured my hand, so my texting really is bad. Sorry.
Oh, sorry. Sorry to hear that. Thank you very much for everybody else. Are there any other questions? If you have them, you can put them on the chat or in the Q&A. We'd love to answer anything. We've also posted the post-training survey. And Alyssa, if you can tell us a little bit of why it's important to get that post-training survey and how it helps the work that you guys do.
Yeah, so the amount of answers that we do receive back will go directly back to Cal OES, and I'll let them know, hey, like these individuals, they might not have known this much about GVROs, but by the end of our training, we were able to exponentially, grow the number of knowledge after. It does show them that this is working and this campaign, this training is working. So with that, it will be able to have this campaign continue within the next couple of years, because it is actually scheduled to end in December, but we're really hoping for it to continue. So if you all don't mind, I know you guys were on here for a long time for us, so we really appreciate the hour, an hour and a half that you guys have been on. If you can go on that post-training survey really quickly, it only takes about 2-3 minutes, just to show the knowledge that you might have learned in this training, and it'll really help out our campaign.
All right, wonderful. And Alicia, I'm going to hand it back to you.
Sure, thank you. I just want to thank, both Jeff and Alyssa. This is such valuable information, and, with everything you covered, it's so obvious that it's truly life-saving. So, I know on our end within the council, we'll continue to share on the platforms that we facilitate and encourage, all of the participants in the council to educate themselves. And thank you so much for being willing to share the PowerPoint with us, because we will distribute that widely as well. It still doesn't look like any other questions have come in. Diane did put her email in the Q&A, so can copy paste that over to the chat. There. But again, thank you so much, Jeff and Alyssa. You're so knowledgeable on this topic, and we're so lucky to have you join us today. Thank
Our
you.
pleasure, and thank you for all the work you do on a daily basis and keeping us safe and healthy. So thanks for the time. And again, some of you will get emails if you have any questions, comments, etc. Happy to hear it.
Thank you. And to everybody that has joined us as part of the DV Council monthly meeting, we just want to remind you that our next meeting is scheduled for April 21st, and it will be a presentation from Dr. Wexler here from San Diego on recognizing warning signs of abusive relationships. So very interesting. We hope to see you there, and you should be getting some updated emails with information on how to join us for that presentation. Thank you very much, everyone. Have a wonderful rest of your day.
Thank you.